Hello again, everyone. Zachary Lawrence here of Parkside Property Management with my friend, mentor, and eviction expert, Dennis Block. Long time no see, bro.
Hey, you've been a long time away from these podcasts, and everybody's clamoring for it.
Why is that microphone in your ear? Is this not the mic that we're using?
I've got two, but you know what? For the purposes of
He's
this
going
telecast,
to take calls during the podcast, ladies and gentlemen.
And you know what?
That's what a multitasker he is.
and that's what I can do for
That's
you.
where you can take calls during the podcast.
So
okay?
how have you been for this time period?
I've been pretty good, Dennis, and as you know, excuse me, you've handled multiple evictions for Parkside Property Management, and because that's what you do, and you're the go-to guy in the business for evictions. Now, I want you to candidly tell our listeners something, what I call the Schreiber game, and I want you to tell our listeners what the Schreiber Project is about, what landlords should know about the Schreiber Project, and for those that are not aware of it, when a tenant is served with an eviction and suddenly you get papers from a pro bono lawyer that says you're a slumlord, they did pay their rent on time, we're not signing a contract, and the client, your client, is shelling out thousands of dollars, whereas the tenant is on Easy Street. He's not paying his lawyer. And it begs the question, who is the winner and who is the loser?
Well, you're dealing with a situation where tenants now are afforded free legal representation, specifically in the LA County, Los Angeles Superior Court. These attorneys will immediately ask for a jury trial. They'll conduct discovery, and it becomes a situation where a simple eviction case, which used to take about, a 20-minute trial and minimum fees, is now blown into a relatively big ordeal for the landlord, and of course a financial loss for the landlord, not just in terms of the attorney's fees, but in terms of all the lost rent. In many cases, the landlord will waive the rent just on the basis of having the tenant vacate the unit. There is no basis upon which our society, the state of California, should be giving free attorneys to tenants in eviction cases. I can understand the situation where if you're going to lose your life or liberty, they're going to put you in jail. I can see an attorney being appointed in that situation, but certainly not in a regular contractual basis between a landlord and a tenant. Yet, these attorneys are appointed, and they're given free representation with regard to their eviction case, and in addition, they're asking for jury trials.
But okay, Dennis, let's put this in even more simple terms that our listeners and myself can understand. Could Donald Trump get a free attorney? Could Bill Gates get a free attorney, or does one have to qualify for a free attorney?
One generally you would think would have to qualify, but their questionnaire that they're asking in order to be appointed a free attorney basically means that anybody who fills out the paperwork is going to get a free attorney, and they're told to ask for jury trials. Now, it's not just the free attorneys. There are many different organizations out there, law firms for profit, that will clearly represent these individuals, and they're into the game of making a landlord understand that the costs are going to be so high that they're asking for the landlord to pay the tenant to move, and of course they get the lion's share of those payments.
You mean the tenant gets the lion's share of
No, the attorney.
The attorney.
These are not pro bono attorneys. These are attorneys that take on these cases, charge a minimal amount, if any, but their payday is based on forcing the landlord to pay them, to pay the tenant to move based on relocation in order to get rid of the case, even though it's the tenant who owes the money.
So a wealthy man, hypothetically, could go to the Schreiber Project, okay, which is explain to our landlords out there exactly what the Schreiber Project is.
Well, the Schreiber Project was a project that's appointed by the state of California, funded by the state, which will appoint attorneys to anybody basically who asks for it. And so no money changes hands. They'll represent the tenant. They'll ask for jury trials. and obviously conduct a bunch of what they call discovery, which again drives up the cost of these lawsuits.
Okay, now if somebody calls you, Dennis, and says, I've got an eviction, I've hired you for this eviction, and I'm up against a tenant who is basically driving up my costs. He's paying nothing, I'm paying everything, he keeps asking for more discovery, he's asking for a jury trial, he's asking for this and that, and not only does he owe me money in rent, it's costing me thousands of dollars in legal fees. Now, this is not a new argument. I'm not telling you anything that you haven't heard before. What is your response to that landlord who finds his finances being drained when he's trying to do the right thing by getting rid of a non-paying tenant?
I can only tell you the experiences that my clients face, and that is in most of the cases we do get the tenant to vacate the unit. So there is of course, an advantage to that situation, especially if the rents are low. So the landlord's going to get an additional revenue for the unit, but it is going to cost some money. But in most cases, we do make a settlement, or we go to trial. We're very successful if we actually do the jury trial and have the love of having a tenant thrown out. We just filed, for example, a cost memorandum against a tenant where we're seeking $28,000 in attorney's fees against us because we did prevail in the jury trial eviction. But again, the landlord is confronted with a tenant who is not paying rent, doesn't want to move. The landlord really has very few choices in that situation. However, this week, I came up with a new idea on how to somewhat defeat these cases where these bogus claims are made. I know you were involved in a case that they asked for a jury trial, and your case, I presume, was based on non-payment of rent. And I'm sure that they said that bunches of things were wrong with the premises. Well, I'm changing my 3-day notice to pay rent or quit, and this telecast or podcast will be the first one to hear what we're doing.
Bulletin.
Well, it's in my current forms that we use internally here in the office, the 3-day notice. It will be posted online probably by this weekend.
This week, okay, folks.
And this is what we're going to say in a standard 3-day notice. We're going to have a little paragraph on the bottom. And the paragraph on the bottom is going to state something to the effect of, we are not aware that there are any problems with this place, nor have you communicated any problems to us. We take our responsibility as a landlord very seriously. If there is anything wrong with your premises, please communicate that to me in writing. We will immediately investigate that and correct anything that requires correction. That's going to be in every 3-day notice. Now, what's that going to do?
Yes.
What that's going to do is to tell the world that at the time we served the 3-day notice, prior to the time they lawyered up, got an attorney, and then started checking off boxes of everything that was wrong with the place,
Right.
we have it on record saying, hey, we didn't know anything was wrong, and if there is something wrong, please send us something.
We didn't know, excuse me, allow me to fine-tune your language. We didn't know, or we don't have records of any complaints by you. In other words, wouldn't that be taking a higher road than claiming ignorance?
I did say that you have not informed us, and we don't know that there's any problems with your premises.
I believe that's wonderful language, by the way. You have not informed us.
No, that is already in the paragraph that's contained in our internal 3-day notices here.
And that will be up on the website.
And that will be up on the website.
You have not informed us.
Right. Now, if you have a situation where you're starting a jury trial and their big defense, and there are others, but their big defense is habitability. Mm-hmm. And it says clearly in the 3-day notice that that we don't know that there's something wrong and to send us in writing. You can have what they call an evidentiary hearing, which is prior to the start of a jury trial. And that is where a judge will look at certain evidence and determine whether it should be excluded or not. I'm guessing that based on this 3-day notice, that we can actually have a judge review it, show that in fact no notice was sent to the landlord that there was something wrong with the place, and therefore this evidence would be excluded anytime the tenant would try to bring up the defense of habitability. So we're trying this. We're trying anything that we can, because it is so easy to say, I told the landlord something was wrong, and in fact they didn't want to corrected, and then in desperation I withheld the fact. You know, this concept of the doctrine of habitability, the warranty of habitability, where case law authority and it's now codified in the civil code, allows a tenant to withhold the rent if a condition exists and the landlord callously refused to fix it. It was a very feel-good type of legislation that was addressed. The truth is, like everything else, everything is bastardized, and tenants don't use this as a shield to protect themselves. What they do, quite frankly, is they use it as a sword to stick it into the hearts of landlords who are taking care of their buildings, and all they want is their rent.
Dennis, would the law allow you to include contractually with a tenant something like this in layman's terms? If you are served with a 3-day notice and you complain that, for example, your plumbing is stopped up after the 3-day notice is served, and you cannot produce a record of having made this complaint within the last 60 days, let's say, that claim is hereby waived.
Well, I don't think that would be legal. You are going to be able to bring up in evidence issues what occurred with the tenancy, etc. However, by putting it right into the 3-day notice and stating that, hey, if there's a problem, please put it in writing. If they can't produce that writing in an evidentiary hearing, which would be prior to the start of a jury trial, I think you have a very good shot of excluding all this evidence. And the best part about it is it's at the 3-day notice stage. Because once the lawsuit starts, they're going to get these free attorneys. They're going to say whatever they want to say, make up whatever evidence that they want to make up. You know, we know a law firm, for example, that literally finds cockroaches, puts them into a bottle, and uses it for their trial. They bring that in to show to the jury how bad the place is. And of course, they've collected these pests from any place and every place, except for, of course, the apartment in question. So I think by putting
You mean there are lawyers out there collecting cockroaches and bottling them?
Yes.
Is that a billable event?
if they get down on their hands and knees.
I can just see the invoice for that one. Go ahead.
Yes, but in any event, I think it makes sense that before they have an attorney involved, they just get served with a 3-day notice.
Right.
They don't comply with that. There's not been a writing, and then magically, all of a sudden, they start doing it now. So
now, does a tenant's request for your evidentiary hearing have to have been a request made in writing? I'm the tenant. I can just say, you know, Your Honor, I've called this guy 100 times telling him that my toilet was stopped up, and he just never returned my call.
And you're 100% correct, but the 3-day notice specifically asks for it to be in writing. Now,
does it have to be in writing?
Well, it doesn't have to be in writing, but I think it shows evidence to the court that it's not a valid claim of habitability.
Can you compel a tenant that any maintenance requests have to be in writing in order to be valid?
You can put that into your rental agreement. If you look at my rental agreement, which is online at evict123.com, you will see that we have, except for emergencies, all repair requests must be in writing. And again, we use that too in terms of trying to defeat habitability claims that crop up when these tenants defend themselves. But now we're also going to start putting it into the 3-day notice. By putting it into the 3-day notice, we're really setting the tenant up that, hey, this is not a valid habitability claim. You never told us, which happens, I can't tell you how many times we start an eviction case. The tenant files an answer, so they're contesting the case. Mm-hmm. And one of the defenses in their answer, they check a laundry list of items off of all the things that aren't working. The plumbing's not working, the paint is chipping, there's pests, the windows don't lock, whatever the story is.
There are cockroaches.
Right, and the landlords do the same thing in every case. He never told me that, and it's like they're incredulous to look at this list. If I had known something like that existed, I would have fixed it. Or the truth is that doesn't even exist. Yet the tenants will put that in their answer. I think now that by putting in this in the 3-day notice, I think we're setting them up to a situation where it's going to be hard for, if the judge doesn't want to kick it out based on an evidentiary hearing, even if it goes to a jury. What do you think if you're sitting there as a jury person says, look, it said it right in the notice that I'm begging for the tenant to tell me something wrong and that I will fix it. Do you think that that was the true reason why he withheld the rent? So I think we've got a formula here that we're going to try, and we just came up with it this week, I might add.
Will it stand up in court, that clause that you're unilaterally putting into your 3-day notice?
I think it will. I think, of course, I mean, the judge can do whatever he wants, but I think on an evidentiary hearing, it'll go a long way to say this is improper evidence to talk about a habitability.
Okay. Dennis, tell me something about a tenant that is in front of a jury, about to be evicted, and the weight of the evidence indicates that he didn't pay his rent on time, but he comes to court in a wheelchair, 75, 80 years old, and
Let's make him 90.
Okay, let's make him 90. Tell me about any defenses or advantages that a tenant may have in court if he is elderly or if he is handicapped.
Well, of course, sympathy does creep into the minds of the people who are sitting on the jury. However, the way to get around that sympathy issue is obviously your client has to seem like a very reasonable person that, hey, I didn't immediately start this eviction case. We waited 2-3 months for the rent. And then what else can we do? The rent still wasn't coming and we were forced to bring this action. But when you have a jury, unlike what you see on TV, the jury just doesn't say guilty or not guilty. The jury is given a series of questions that they must answer, and it's almost like they're like directed to a specific verdict on this verdict form, and it says, do you find that the landlord rented to this tenant? Do you find that the tenant's rent was X amount of dollars? And you go down the laundry list, and finally they're being steered to the correct decision. If you find that the notice was served correctly, did the tenant pay the rent within the 3 days? So you're steering them to the right thing, and they have to fill out this jury form.
So you're telling me legally they may not factor in the fact that this man is handicapped and elderly and probably not going to have a place to live. They can't. That is not relevant to their decision-making process.
Well, if you're forcing them to go down the laundry list,
Yes.
then they don't really have the chance to steer off based on sympathy factor.
Okay, now let's say the guy's evicted. Let's call him the old man. Okay, does the old man have recourse? Can he apply for some kind of an economic hardship? What else can he do to stay in his unit?
There is something called an 1179 motion, and it's under the Code of Civil Procedure. And what that code section states is that even though a tenant is found guilty of unlawfully detaining the premises and therefore subject to eviction, the court can rule based on a hardship factor that the tenant can remain in possession, that the tenancy is reinstated if all the rent is paid. That's up to the purview of the judge, and you can file an 1179 motion. But in most cases, that is not listened to. A lot of times, the tenant doesn't have the money to pay. So
wait a minute. The Schreiber people cannot file an 1179 motion?
Of course, anybody can file an 1179 motion, but number one, you'd have to have all the rent to pay. The Schreiber people are not going to front the rent for them.
I get that part. So basically, Dennis, I mean, if somebody calls you and says, I need to evict an 80-year-old man who, you know, is eating from a straw, what fiduciary duty would you have to that potential client and say, even if we're successful, this guy may pull an 1179 motion and stay there? Is that something that you would feel as an officer of the court to disclose to your tenants?
Well, you don't know. First of all, very small percentage of cases, unlike what you're saying here, are really turned into jury cases. Most cases, the tenant doesn't contest the case at all, and they're evicted. And if they do, they don't necessarily get a free attorney.
Really?
They fill out their own papers. There is a percentage of cases, yes, where they're gonna ask for a free attorney, get it, or go to a law firm that's gonna ask for a jury trial. But again, it still is a small percentage.
What percentage, and this is a good statistic for our landlords to know, what percentage of evictions are contested and what percentage are not contested?
I would say percentage of evictions that are contested are about 33%. Of that 33%, I would say maybe 5%, maybe a little more, is actually contested where you have someone asking for a jury trial. It's still a small percentage. If you're in certain areas, of course, then it can go higher. But in most situations, you're not going to deal in a situation where you're getting a jury trial in every single case.
So 33% of your cases are contested. They are contested.
About 33% are contested.
And of those that are contested, 5% of the 33% end up in front of a jury.
Or a jury trial is requested
Okay.
at the very minimum. On
Okay,
that.
fine.
But don't forget, you're dealing with a situation where the tenant's not paying rent. So what's the landlord's choice? He can take a gun and shoot him? I don't think so. He can take off the doors to the unit and force him out. That's only going to get the landlord a lawsuit. You have no other choice. If the tenant doesn't want to pay, what is the choice of the landlord other than to file an eviction? So that's exactly where we stay.
And we've discussed this before, Dennis. You serve the tenant with a 3-day notice, okay? And we've been doing this 20 years. You're a good cop, I'm bad cop, okay? You've served the tenant with a 3-day notice, and the tenant hasn't responded. You file an unlawful detainer, and suddenly, and we're going back to the Schreiber Project now, the landlord is besieged with paperwork and discovery and questionnaires, which, frankly, increases his legal fees to you or whoever else he might hire, okay? What would you say to the landlords out there that would ask you to approach the tenant and say, what can we do? What can we do to make this right? All the landlord wants here, and presumably all the landlord does want is his money. He wants his rent.
And why wouldn't the tenant, prior to going through all this, just pay him the rent? The reason,
I don't have an answer for that.
And I do. It's really simple.
Okay.
They didn't have the rent. Okay, and that's the reason why.
You're telling me that the reason that 100% of the reason that tenants don't pay is because they don't have the rent?
Are you telling me it's because something was wrong with the premises and the landlord, like you, your management company, didn't want to fix it?
You've been telling me for 20 years that tenants, have a myriad of reasons why the rent isn't paid. Maybe they just bought a new car.
Yeah, but it all
and maybe their priorities for the month of December is to buy their family Christmas presents rather than make their rent. Those are your words,
but
not mine.
don't forget also, you're dealing in, most of these cases are rent control cases. The benefit to the landlord, which you're ignoring, the benefit to the landlord when you evict this tenant is that you get to raise the rent to market level. If you're talking about a tenant who's paying $700 and you could get $1,700, you're making $1,000 more per month. If you're thinking of selling the building, multiple factors is dealing with maybe 18 times gross. What's the math on 18 times $12,000? What is that increasing the value to your property? So the monies that you're spending to potentially get this tenant out is going to be tenfold back to you. So, but I do want to move on for the limited time that we have. I have another.
How much time do we have? I know you got a clock over there.
I do?
Yes, you do.
We're going to just stop and look at this clock?
No, we're allowed.
Okay.
How much time do we have?
We got 6.5 minutes.
And
then you know what happens? You become a pumpkin.
That's right. You throw me out of here.
All right, so let me tell you a new crack that I have found for rent control. We were actually doing this procedure in the years 2005 to 2009. Then a case came down that we were on the shy side on that said we couldn't do it. But right now the law has changed. So for you landlords out there that have, this is your criteria, otherwise it doesn't work for you. You have a tenant that is paying low rent, under rent control, and that tenant is under Section 8. We now have a way of forcing the end of that tenancy, and then in most cases being able to raise the rent to market value.
In plain English, you can a landlord terminate a Section 8 contract anytime he wants?
The truth of the matter is a landlord can terminate the Section 8 contract.
So
That doesn't mean that you can ask the tenant to move. But the landlord is now allowed to demand the full amount of rent from the tenant. In a Section 8 situation, you're having subsidized rent. So if the rent, for example, is $2,000, the tenant is paying $200, the state is paying, or the city is paying $1,800. You can now terminate your relationship with Section 8. There's a specific guidelines of how you have to do it to stay within the law, and then demand that the tenant pay the full $2,000.
Well, let me ask you a question. If they're getting if they're getting $1,800 from Uncle Sam and $2 from the tenant, they're getting $2,000. So where are we going with this?
I was just giving you an example. In most situations, you're dealing with a $2,000 apartment where they're getting a total of $900. Well, $100 from the tenant and $800 from the city.
So the unit is not up to market.
Right. I said this works for rent-controlled units where the rent is very low and you're dealing with a Section 8 tenant.
Okay.
If anybody has a situation like that, I urge you to give my office a call, 1-800-77-EVICT, the number that's right behind us there. And you can talk to me about this, and we've been doing a lot of these recently, and I'm very confident that.
What are we calling it? Is there a name for this? Is there a name for it? Is it
just it requires a 90-day notice, so it's a 90-day termination of Section 8.
Okay, so
and in many cases, landlords just don't want to be on Section 8. The requirements, maybe they tried it, but it just doesn't look good for them anymore. So
what do you mean it doesn't look good?
The requirements that Section 8 makes with inspections and paperwork and trying to get through to them is very burdensome for landlords. And in some cases, you'll deal with a situation where the tenant will not open his door for an inspection. Therefore, the house or the unit doesn't pass. And because the unit doesn't pass, now the Section 8 funding is cut off to the landlord, having nothing to do with the.
So if I understand you, if a tenant is paying $100 and the rent is $1,000, and Uncle Sam, Section 8, is paying $900, but the market for that unit is $2,000, all the landlord has to do, if I understand you, is terminate the contract with Section 8 and notify the tenant that their rent is going up from $100 a month to $2,000 a month. Is that what you're saying?
Well, it's whatever the total rent was. We're not increasing the rent. So if the total rent was $1,100 based on what the tenant share was plus whatever the city's share was, what we're saying now is, Mr. Tenant, we're not increasing your rent. Your rent was always $1,100.
But you're shifting the burden onto the tenant to pay that amount, which is basically a way of saying, we know you cannot afford this amount, we want you out, and therefore, after you're out, we can then increase this unit to market level. So it's a sneaky kind of way to, what you're saying is basically, landlords, here's a way to kick out your Section 8 tenant and raise your units to market level and do it legally. Isn't that what you're saying?
It is what I'm saying, except I don't think it's sneaky. What I think it is working within the guidelines of the law for a landlord to make profit on his income property and shouldn't be restricted like any other person who sells services and goods to the public.
And there will be no blowback whatsoever based on the Dennis Block, get rid of your Section 8 tenant paradigm. No blowback from the tenant, no blowback from the law. This is a clean transaction. Is that what you're saying?
It is a clean transaction, but there's many different nuances to this which the client must be made aware of, and which
we have 30 seconds left. You've outlined your Dennis Block, get rid of your Section 8 program, tenant program, okay? What can go wrong? Honestly,
there's nothing that can go wrong if the client follows the procedures. I can't go through all the procedures.
You don't have time for that, okay.
But I can tell you that we're working these on many cases right now. But again, I don't know how many landlords really are going to qualify for this help. But if in fact, again, if you have a tenant on Section 8 where the rent is low, or you just want to get off of Section 8, maybe it's not an issue of dealing with more rent or anything to that effect. You just want to get off of Section 8. This program will allow you to do so.
Okay, Dennis, always informative, always a pleasure. And we're done for today, folks. This is Zachary Lawrence of Parkside Property Management, and this has been my classroom for the last 25 years. Anything I've known about landlord-tenant law has come from this guy. So that's it from here, and we'll see you on the next podcast, Dennis.
And if anybody wants to reach me, you can reach me at 1-800-77-EVICT. And you can see that number right over my shoulder, or catch me on the internet at evict123.com. I also want to tell you that this man is the golden man for representing income property owners. His management company is parkside123.com. I personally recommend him. He's great, and you're the man.
Thank you very much, Dennis.
Thank
Bye,
you.
everybody.